Great report there by Anthony Velez. We are going to cover that case. We're going to be live in it. I'm keeping a very careful eye on the courtroom feed of this bizarre 35-year-old murder case. Now, again, that is a live feed right there, ladies and gentlemen. We're going to jump into it as soon as trial starts. But I want to talk a little bit more about it because it really does have a lot of details. So joining me on set, I'm very happy to welcome here on the program trial attorney Eric Weitz. Eric, great to have you here.
Hey, thanks for having me.
So what do you think about this case? 35 years old, this trial. I mean, what do we know, maybe if not anything yet, about how we got here today? What tip do we know? Do we know anything about this case?
Yeah, we don't know what the tip was. We just know a tip came out in last March out of nowhere. And it's interesting because they seem to have something, because there are a lot of people, for a cold case, 34 years old, there's a lot of people charged here, and it goes pretty deep, including people in law enforcement.
How do you get the proper witnesses to recount something 35 years ago? I imagine there's a difficulty when we have cases 4 years ago. But, you know, we keep hearing about these cold cases happening. How is this one going to be tried?
Yeah, you know, it's very similar to what you're seeing even in the Price trial, where the wife had given multiple different at least recounts of what happened as her memory either deteriorated or got better. You know, I think the cross-examination of some of these witnesses is going to be pretty clear. The defense's best witness is time.
And the people that are charged, we got brothers-in-laws, we have another law enforcement are also charged. I mean, it seems like a cover-up. There's one former detention officer, Gregory Huffman, is charged with obstruction of justice, and violating his oath of office. This is something straight out of a movie.
It is, and clearly the investigators and the district attorney think they have a pretty strong case to have charged this many people going this deep. And the interesting thing is a lot of them seem to also be related. So it seems to be a common thread.
I mean, you can't make this stuff up. We're going to continue this case. We're going to cover the Gebhardt case as soon as we have trial begins. Again, that's a live feed. The judge is just beginning right there. But that is not the only thing that we're talking about here on Law and Crime. I keep saying we have a lot to cover. Before we get into any of our live trials, we want to play you the top crime stories of the day, as we always do, here on Law and Crime. Thank you again, Anthony. You can go to lawandcrime.com to learn a little bit more about those stories and also the top legal, entertainment, political stories of the day, again, on Law and Crime. But before, again, we go to our live feed in either of the courtrooms that we're going to be in today, in Kentucky and Georgia, I want to talk a little bit more about that false rape story, again, because it has some really weird details about it. So, again, I'm here with Eric Weitz. What is this woman facing right now?
Well, it's a felony, so she could be facing prison time. I suspect that they're already building the defense by claiming that I think she has bipolar disorder and other things that may have led to poor judgment.
Well, look, we talk about sexual assault, we talk about rape, I mean, all different kinds of things that happen in our society. But this becomes a real issue, too. How do you prevent these false reports from happening? We've covered a number of them here on Law and Crime, and you keep seeing them in the news. What about this case could serve as a lesson moving forward?
I don't know that there really is one, because I think we live in really interesting times between having the power of the Me Too movement on one side and then the concerns on the other side. I think people are very sensitive to it, and I think if people do bring up allegations now, given all the publicity around these issues, they're going to be deeply investigated. And I think if they're found out to be false, this is what needs to be happen.
This is a unique situation that she may have had a mental health issue, right? We don't always see that. Sometimes we see false reports because of attention or because of, extortion, different kinds of ways. So again, this is a little bit of a different kind of case, again, if she does in fact suffer from some sort of mental disease.
It is, although she did indicate, at least I read in one of the accounts, that she had allegedly had an interaction with somebody earlier that day, earlier that night, that she was ashamed of, that maybe she hadn't stopped, and that she was angry about that, and she didn't necessarily want to reveal that to her mother, who was the first one to call and report this.
I can't help but think about the accused, though. The people who are, in today's day and age, you have somebody who's accused, that can be a blemish on their image, their record forever, just being accused of something like this. So how does that person, or how do people who are in this situation move forward?
Yeah, it's difficult. Like one of the other cases you were reporting on recently, when people win vindication, they can go to court and they can try and clear their name, but very rarely does the court process provide that opportunity. It's very difficult.
Yeah, it's a really disturbing case on a lot of different levels. So we're going to cover more about it here on Law and Crime. And again, you can go to lawandcrime.com to learn a little bit more about it. But as I always say, that is not the only case that we're following. I want to take a step back and talk about another case that we've been carefully monitoring. I'm looking at the courtroom feed right now. It is the case of the two men who were charged with the murder of a Marine named Jonathan Price. Quincinio Canada and Dwan Malazim are on trial. They are an uncle-nephew team, and that becomes a really big issue because at least one witness in this case overheard perhaps Mr. Malazim say to Canada, "Come on, nephew," which is a really big identifier. The defense has been very big at saying this is a case of mistaken identity. That is a live feed into the courtroom. That woman with the short blonde hair and the glasses is, in fact, Megan Price, the wife of Jonathan Price. She was shot in the leg, testified about how her life has never been the same. In fact, not only just because her husband was killed, but because of that injury to her leg. She suffers balance issues, back pain. She really will never be the same. And she had the opportunity to face the two people she believed committed these crimes in court last week. Now, what I want to do for anybody who just joined us or anybody who wants a recap about this case, we have a short report about this Kentucky trial. So let's play that for you right now.
The Kentucky trial of the shooting death of a Marine is underway. 26-year-old Quincinio Canada and 34-year-old Dwan Malazim are charged with murder and assault for an incident outside a bar in 2014. The two men allegedly approached Corporal Jonathan Price and his wife Megan when one of them tried to snatch her purse. When Jonathan got involved, a fight started, and the corporal was fatally shot in the back. Megan suffered a non-fatal bullet wound to her leg. Both men are also charged for a robbery 6 days prior to the Price shooting. Law enforcement connected them to both crimes by identifying the .45 caliber handgun used in the robbery and the shooting. For Law and Crime, I'm Rachel Stockman.
Thank you, Rachel. You can go to lawandcrime.com to follow that live trial. We are going to cover that there because our main priority right now is going to be that Georgia case that we talked about at the beginning of the program, this 35-year-old cold case that is now back on trial. I mean, we have to cover this. This is pretty unbelievable. Again, I'm here with Eric Weitz. This is a racially motivated killing. That's what we seem to understand here, that this young man who was killed back in 1983, Timothy Coggins, they believe that Mr. Gebhardt, who is going to be on trial for this, he did this because of race.
Yeah, he was heard saying that this gentleman was messing with his woman friend, white woman friend, and that, I think, is the prosecutor's central motivation theory for the case.
I mean, this is pretty unbelievable. I think we have audio in the courtroom right now. I see the judge speaking, so let's go live into this Georgia courtroom right now. Okay, so that was the prosecution and defense's opening statements in this new case out of Georgia that we're covering, a 34-year-old cold case that's now back on the trial. We're talking about who killed Timothy Coggins back in 1983. And one of the defendants is now on trial, and this is a man named Frank Gebhardt. We heard how the prosecution believes that he is their man, along with other individuals who helped with the crime and helped cover it up. Well, the defense was really pointing the finger at the fact that, hey, this is there were mistakes made in this crime scene. There were mistakes made in the investigation. There's a total lack of evidence. And let's not also forget that all of the people that are going to come forward and say that Mr. Gebhardt admitted to this crime, really, who are they? Really, where is this information coming from? So let's talk a little bit more about this with trial attorney Eric Weitz. What did you make of the prosecution's opening statement? Let's start there.
Yeah, I mean, substantively, it was textbook. Very common types of things that they would point out. What I would worry about is that she came home really strong really early. And a lot of times juries aren't ready for that. Juries are not ready for such powerful emotion and conclusions before they've gotten to hear all the facts, and they haven't yet. But other than that, she kind of textbook, she laid it out. I suspect, given the depth of all the people involved, as I said it before, she's holding something back.
Well, let's talk about, there's a serious problem with the investigation back in 1983, and so much evidence, you just heard it from the prosecution and the defense, is missing. Why would all that evidence go missing?
Yeah, so we looked at it real quickly. Spalding County, Georgia is a county of 65,000 people. It's not a big county, fairly rural, south of Atlanta. I can't imagine they have any kind of procedures like you'd have in a big city to maintain evidence for that long. This is 30-something years. The number of crimes that they've investigated, the amount of evidence they've had to retain, it's not like they just have limitless warehouses. So a lot of it has either been disposed of or gone missing. It wasn't, although this case had never been solved, it wasn't like there was an open investigation going on.
You heard the flavor from the defense where he said it was just another black kid who was killed, right? 23-year-old black kid, who cares? Georgia, 1980s. Is that maybe one of the reasons that we don't have the evidence?
Yeah, I don't know. This case has all the hallmarks of the next movie, between corruption involved with law enforcement, between the racial overtones involved here, rural Georgia, the whole thing. It could be, although I don't know how that argument plays in 2018 in front of this jury.
I want to give our viewers an update and then like your perspective on this. What's going on right now is we were just alerted that the next witness who is going to testify in this case was watching the live stream of the openings, and this witness was not supposed to be. Said that this person might be held in contempt of court, ordered her 20 days in county jail. Wow, that just came down. What do you think about that?
Yeah, this judge means business.
Yeah.
You know, we have a big problem.
Let's listen into a little bit more of it. This is live in that Georgia courtroom.
To the integrity of their testimony and of this case, ma'am, you'll go into the custody of the sheriff at this time and remain so, and I'll readdress your incarceration after your testimony is complete. Okay, you'll go with them, please. When does the state intend on calling her as a witness?
Judge, we'd like to discuss it. We may not call her to testify at this point.
Well, if you clear her as a witness, let me know and I'll readdress her incarceration.
Yes, sir, Your Honor.
Okay. We can bring the jury back in, please.
This is why we love covering the live trials. There's always excitement. That witness, the first witness for the state, was just held in contempt of court for watching a live stream, maybe our stream. Hey, listen, we'll take the press, of watching the live stream of the opening statements when she was not supposed to be. She was just ordered to 20 days in county jail. Let's bring back in Eric Weitz. What do you think about that?
Yeah, you know, sequestration's the real thing. If a judge doesn't want you hearing what other people have to say, you can't listen. Apparently, she was out in the hallway watching the live stream and listening.
Why is that problematic? Why is that a problem?
Well, because she's supposed to just come in and give the facts, not facts based upon the slant of either side. Here she's being called by the prosecution. She got to hear the prosecution's theory and the defense's potential rebuttal. She's not supposed to be hearing that and kind of prepare herself. She's just supposed to give the facts that she knows.
I know we have to jump back into the courtroom soon, but I'd like your perspective. We were talking a little bit about the prosecution's opening, this lack of evidence, but talk about the brutality of this. Does that give an identifier about who might have committed this crime? Because we keep hearing about the vicious nature in which Timothy Coggins was killed.
If the crime was maybe closer in time, I think that would be a factor. But here it's been so long. Unless there's some modus operandi that this is what this guy has done often, I don't think it's going to be an indicator.
Well, we'll have to see. The first witness right now is Warren Tillman. We're going to go live right now into that Georgia courtroom. Okay, so that's Warren Tillman. He's the first witness, the medical examiner in this case, is providing basically a background on what an autopsy is. We're going to jump back into the courtroom for a minute, but I want to talk to Eric Weitz, who's our guest this morning, because I got to give you credit, you said something very good during the defense's opening statement. They were making the point that where does this information come from that the defendant made statements to people that he committed this crime, that he was the one who killed Timothy Coggins? And right before the defense said something, you said, what, I bet it's from a child molester. And sure enough, that's what he said. That's what he said, and I thought that was a really interesting point. I know we have to jump back into court, but you knew that. You knew that with the reliability of that testimony.
Yeah, there had been some indication in the press that they were courthouse snitches, and the point I was making was, with just the prosecution's luck, it's going to be a very offensive crime of the type of person who's going to come forward 30 years later to try and help prosecute somebody, because potentially they may find a way out of prison.
Yeah. We're going to jump back into court. Now this medical examiner is going into Timothy Coggin's autopsy. All right, folks, so one of the reasons we're not able to show a lot of this, we don't want to show too many graphic photos that are being displayed to the jury, because this is the medical examiner going into the wounds of Timothy Goggins, and you can hear the brutality of it. And that's what I want to talk about a little bit more, about why this is being presented to the jury. It's not just for a gory factor, I'm sure. But again, I'm here with Eric Weitz, trial attorney, our guest for this morning. Why do you think this is being presented to the jury, and what does it tell you about the overall narrative of this case?
So I think there's two reasons. The first reason is to kind of establish exactly how the death occurred, and to get the jury at least the shock value out of it, to whatever extent it still exists. But the other reason is to show that this was an aggressive crime, as opposed to that this could have just been some sort of fight that got out of control, or that this is something that happened in an unintentional manner. So this is really meant to lay the foundation for their murder charge.
Especially when they're saying the motive was rage-fueled racism, right? Isn't that what they're going for? That this man absolutely hated, a white man absolutely hated this young black man because he was fraternizing with a white woman, right?
Yeah,
that's the way they're going with?
Absolutely. But they're probably not even into their best evidence yet, because, as we've heard, after the stabbing, they hooked him up through a chain to the tail of a car, and they dragged him up and down a power line.
This is brutal. This is horrendous.
Yeah,
the level of what you're hearing is pretty awful.
It is, and I think the prosecutor is slow playing it here, and they're running the risk of alienating the jury, because if they dwell on this too long, the jury's going to become essentially immune to it, or numb to it. It gets to be too much.
Overkill, for lack of a better word.
And I saw that coming in the opening, and I hope that that's not how she's going to prosecute the whole case, because eventually the jury's going to tune her out.
That's interesting. Well, let's see what happens. We are going to continue on. This is day one of this new case out of Georgia. Okay, so there was a little objection there, and let's try to understand why. Again, I'm here with Eric Weitz. So there's objection about talking about defensive wounds, which becomes an interesting aspect in this case. But can you tell what type of weapon was used? Why was there an objection there?
It sounded more like it was the defense trying to get in the way. It was a technical objection saying that there was nothing in the report that would indicate that the medical examiner had previously given this opinion. Therefore, the defense wasn't on notice that this would be a theory in the case, or that this witness would be giving this evidence.
Defensive wounds are important. What does that tell you about the crime?
Well, I'm presuming that the defense wants this out, in court a bit more, so that they can claim that maybe the victim actually attacked the gentleman who's being accused, Mr. Gebhardt.
Couldn't you look at it the other way, though, that he's defending himself against whoever this attacker is? I mean, it doesn't seem that it's a surprise killing or an accident in any way, or any. Not it can't be an accident, but it's not a surprise killing.
Yeah, no different than talk show TV today. The spin will be going both ways on every single fact.
Well said. Well said. Let's go back live into the courtroom. That was Warren Tillman, the medical examiner in this new case out of Georgia about a young boy, a young African-American boy who was killed back in 1983, and trying to understand who did this. There's multiple people who've been accused, but Frank Gebhardt is the defendant on the trial right now. That's what we're covering. And I want to talk a little bit more about the style and the questioning of those two attorneys, the prosecution and the defense, with Eric Weitz. So we were talking about in the break, the positioning is very interesting. Can you elaborate a little bit more about what you noticed, the way that the prosecutor and the defense attorney were positioned when they were asking these questions?
Sure. So the prosecutor is putting this witness on as their first witness. It should be her strongest witness, But what's most important is she wants the jury to listen to what this witness has to say. She stood up in her opening and said, here's where your evidence is going to come from, and she pointed to the witness stand. So she should be doing everything as the prosecutor with her witness on the stand to get out of the way. I'm surprised that she's standing out in front of the jury, kind of putting on a show with the witness, where the importance is what this witness is saying, not what she's saying. Conversely,
right, the defense.
Right, when the defense lawyer gets up there, he wants the opposite. He gets to use leading questions, which means he gets to suggest the answer in his question. He wants to be in front of that jury, and if you notice, he walked all the way around and got in between the jury and the witness, which some judges won't allow, but this judge seems to have given them free rein in the courtroom. And he wants that jury to be paying full attention to everything he's saying in terms of his questions and hoping that the answers don't really matter that much.
Well, we heard under direct the nature of these wounds. What did what was the defense able to do under their questioning?
Yeah, I don't know. There doesn't seem to be a murder weapon, at least that's going to be admitted into evidence. There's some question as to whether it was a double-edged knife and a serrated versus unserrated. I'm presuming something's going to come up later because the defense kind of trickled that out to let that sit. There's got to be something to follow up on.
Right, because there's a lack of evidence in this case, so much of it is a guessing game. We have a new witness on the stand. Let's go back live into the courtroom.